Hi, I'm Nejat Doğan from the Department of International Relations at Anadolu University, and today's topic is international law. First of all, let's look at the chapter outline. The basic characteristics of international law, sources of international law, international legal personality, state responsibility, and finally dispute settlement. Today we'll touch on each of these subjects. However, I would encourage you to read these from your chapter very closely. And let's touch on the origins of international law. First of all, in fact, the development of Western codified international law started in the 16th and 17th centuries. Especially, we have to mention the Peace of Westphalia in 1648, which established the state system as we know it today. Jeremy Bentham, in fact, has named the field as international law, but you may hear also the subjects such as law among nations. The establishment of the United Nations in 1945 made international law a global system. There are some differences between international law and municipal laws. However, there are two approaches to this subject. The first one is the dualist view, which says the two are separate systems, but according to the monist view, international law and municipal laws are parts of the same legal system. If we look at the sources of international law according to the International Court of Justice statute, there are two kinds of sources. The first one, primary sources, and the second is the subsidiary sources. International conventions, international custom, and general principles of law are primary, which are also binding sources of international law, whereas judicial decisions and the teachings of the publicists are subsidiary or non-binding sources of international law. However, there is the hierarchy of the sources in international law. At the top of this hierarchy, there is jus cogens or jus cogens, which are also called peremptory norms, such as international humanitarian law, such as genocide. Secondly, primary sources of international law. Third, subsidiary sources of international law. So when a case comes before a tribunal, the tribunal first of all looks at jus cogens and apply these peremptory norms to the case. For example, if there is an agreement on promoting genocide or the breach of international law, this is of course against international law, and the state doing this can be held responsible. Secondly, the tribunal look at primary sources and apply to the case, but if there are no primary sources, then the tribunal turn to subsidiary sources of international law. And there are three subjects or persons of international law. These are states, international organizations, and real persons. The subject of the sixth chapter is international organization, and I hope you join me in that video with me on international organization. Let's now look at states and talk about the what kind of activities or the abilities or the capabilities the state or a legal entity must have to be recognized as a state in the international system. According to the 1933 Montevideo Convention, the state should possess, first of all, a permanent population, a defined territory, a government, and capacity to enter into relations with other states. What this means is that a legal entity should have all these before getting accepted as a state in the international system. However, there is a debate in international law whether the fourth criteria, which is the capacity to enter into relations with other states, is a necessary one or not. So this brings us to the discussion of recognition of states in international law. There are two kinds of recognition in the diplomacy, which is de facto, and the second one is de jure or de jure recognition. The first one is extended where a government has not acquired sufficient stability in the state or in the country, but according to the de jure or de jure recognition, it means that the government recognized formally fulfills all the requirements laid down by international law. There are two kinds of theories of recognition, the constitutive theory and the declaratory theory. The first one says that the state must get recognized, and while the second one says this is only declaratory. A legal entity doesn't have to get recognized to be a state in the international system. And there are two modes of recognition, express and implied recognition. According to international law, states can be held responsible in their breach of international law in the system. And there are two kinds of elements of international wrongful act. First one, the state should be, there is kind of a breach between the act and the state, which this means attributability. The fault in the international system or the risk should be attributable to a state, and this state has to have breached of an obligation in international law. This can be a breach of, let's say, international convention or a treaty, or this can be a breach of international custom. But there are circumstances that are precluding wrongfulness in the international system, and these are consent, self-defense, countermeasures, force majeure, distress, and necessity. What this means is if there is this kind of circumstance in the international system on the part of the state, then the state cannot be held responsible of its breach of an obligation of international law. And finally, we'll look at the dispute settlement means. There are two kinds of means. The first one is diplomatic, and second, the legal methods. These are diplomatic methods: negotiation, good offices, mediation, fact-finding, and inquiry. The negotiation is a discussion between the parties. The good offices, there is a kind of a third party in the discussion, and this party encourages the parties to talk. So basically, the third party here is providing with the parties an office, a good environment, and a peaceful environment to talk about the subject that they have a dispute about. According to the method of mediation, the third party, in fact, not only encourages parties, but the third party is present actually in the negotiations. But before a tribunal or before a court, there is a lot of question maybe about the material data and factual matters, and we can solve this problem with fact-finding and inquiry mission in the case. And when it comes to legal methods of dispute settlement, there are two methods: adjudication, which is the leading court here is the International Court of Justice, and the arbitration. Arbitration is a legal method, but it is much more flexible than adjudication in international law. As we said, the leading court is the International Court of Justice in the system, which is also called the World Court. And there are two kinds of jurisdiction of International Court of Justice. The first one is the contentious cases. These are the cases between states, and for this, the World Court to look at the case, states must recognize the jurisdiction of the International Court of Justice, which it means that a state cannot bring a case before the World Court against another state if this another state does not recognize the jurisdiction of the International Court of Justice. Secondly, the World Court can deliver advisory opinions but the advisory opinions can be asked from the United Nations organs such as the UN Security Council, the UN General Assembly, and other United Nations organs that have been authorized by the General Assembly. And this wraps up our video today, and I hope you join me in the next video on international organizations. By then, you take care. Bye.